Hi, I'm Menelik Miller, Legal Counsel at the Cayman Islands Monetary Authority, and today we'll be looking at the new administrative fines regime in the Cayman Islands. As most of you will be aware, the Cayman Islands legislation currently allows the Monetary Authority, or CIMA, to impose admin fines for breaches of certain regulatory laws. However, what is new is 1. The fining process, 2. The fining amounts, and 3. Having all of the fines listed in one place. The scope of the current admin fines regime is currently limited to breaches of certain provisions of the AMLRs. However, the government is in the process of expanding this list of breaches so that in the future, fines will be imposed for an expanded list of breaches in a schedule of breaches within the admin fine regulations. Today, in this introductory talk, we'll be therefore looking at this new regime, and this talk will be divided into 3 broad topics with specific elements. So firstly, we'll be looking at the legal framework, the principles and criteria of admin fines, appeals, and enforcement. So let's start with this presentation. So, as mentioned previously, the summary of the slides is on the screen, and we'll be looking at all of these topics in light of the new regime. And we'll start off with the legal framework, and we'll finish with appeals and enforcement, and everything in between. So let's kick off. The legal framework. The sources of the admin fine regime are the following laws: the Monetary Authority law, its corresponding regulations, the regulatory laws. These include all of the laws that we are very much familiar with: bank and trust companies law, mutual funds law, insurance law, etc., etc. Whichever law is relevant to the industry that the licensee is in. And of course, the enforcement manual, which is on the CIMA website. So where are the breaches drawn from? The question is that the breaches that you will find within the new schedule are actually existing breaches taken from the laws that I've mentioned previously, i.e. the Monetary Authority law, the regulatory laws, regulations, rules, and of course the anti-money laundering regulations. Together, all of these breaches become known as the prescribed provisions. So, what constitutes a breach? Within the law, it states that the contravention of a prescribed provision includes allowing or not allowing a prescribed state of affairs to exist, and engaging or not engaging in prescribed conduct. So on the screen now is an example of a prescribed breach, and this is taken from the existing admin fine regulations. This is Schedule 1. The intention that the government have is to expand the Schedule 1 that currently only applies to a limited number of breaches of the anti-money laundering regulations, and expand this to include all of the breaches in the AMLRs and the regulatory laws and rules and regulations. And as we can see here, each breach or each item has an item number, the law or regulation, or in some instances rule, and the appropriate section, and the categorization. So if you breach this law or regulation, then what will that breach be categorized as? Will it be categorized as very serious, serious, or minor? Each breach will be categorized as follows. So, the question that I've been asked a number of times: who can be fined? Any person or entity licensed, regulated, or even those excluded from regulation, auditors, and members of the public. I've been asked that it seems unfair that a person who's not a licensee could be fined by CIMA. But the retort to that is this. If an entity, for instance, was conducting banking business, providing deposits without the requisite license, without a license, it wouldn't be a licensee. However, CIMA would have the power to impose an admin fine on an entity doing such a thing. That's the short answer. So moving on, where can or the finable conduct occur? And the short answer again is anywhere. So moving on. Moving on to limitation periods. Limitation periods in law are obviously very important, and that's no different here. So within the admin fines regime, the limitation periods are stated within the law. And for minor breaches, they are 6 months. And for serious and very serious breaches, as you can see, 2 years. Now, what's different with this particular regime is that within the law, the limitation period runs from, and we quote, from the date on which the authority became aware of the commission of the breach. So not when the breach actually occurred, but from when the authority became aware of that breach. But the second part of this is, again, taken from the law, is that the authority shall be deemed to have become aware of the breach when it first received information from which the breach can reasonably be inferred. So what we have here is a regime that has a limitation period. And by way of an example is this: if SEMA were to receive an email with an attachment, and in the attachment were details and evidence of a serious breach, and for whatever reason SEMA did not open the attachment, let's say for 3 years, the limitation period would not run from the date on which SEMA opened the email. The limitation period would run from the date on which SEMA first received the information. As under the wording, the authority shall be deemed to have become aware of the breach when it first received information from which the breach can reasonably be inferred. So that certainly places the onus on the authority to check all the information before it. So, how does the authority discover a breach? Through any source. And I've listed a few here, some of the most obvious ones in terms of whistleblowers, on-site inspections, news reports, court cases, court papers, etc., etc. The source doesn't really matter that much, for the simple fact that no matter how the information or the breach or information regarding the breach arrives before the authority will then have to check and obtain evidence of that breach. And they will do so by commencing an investigation, which brings me to the next slide. So, within the organization, within SEMA, the investigations will be conducted by the supervisory division or the on-site inspection unit, and they will be conducted with legal advice from the legal division on how to proceed, and be led by a head or a DHOD, deputy head of the division. So it will be a senior person with conduct of the investigation. And once the investigation has finished and it's determined that there's sufficient evidence for a breach, then a decision will need to be made as to the amount of the fine. We'll come to that a little later. So at this stage, we're just looking at the category of breaches and fines. So you may already know that there are different types of breaches. I think I've mentioned there's very serious breach, a serious breach, and a minor breach. 3 types of breaches. And whether the breach is minor, serious, or very serious is set out in the schedule to the admin fine regulations, as I showed you an example of earlier. And whether a fine is minor, serious, whether a breach is minor, serious, or very serious will have consequences in relation to the maximum amount that an individual or entity can be fined. So let's look at fixed fines. Fixed fines are called fixed fines because they are fixed at 5,000 CI dollars. And they're fixed as the authority, SEMA, has no discretion to either increase or decrease that amount. They are fixed at $5,000. If the breach continues, an additional $5,000 fine may be imposed up to a maximum of $20,000. In contrast, we have discretionary fines. They're called discretionary fines, as CIMA does have a discretion in relation to these fines, and the discretion is in relation to whether to impose the fine and the amount of the fine up to the statutory maximums. So in relation to discretionary fines, there are no minimums, just statutory maximums. And as you can see from on the screen, in determining whether to impose a discretionary fine, the authority must consider all relevant factors, including the prescribed criteria and the 4 principles, which we will discuss in the next slide, or the one after this one. So here's an example of the discretionary fine amounts. We'd explain that the fixed fines were fixed at $5,000. Serious and very serious fines, the maximum amounts are shown on the screen. So the maximum amount for an individual on a very serious breach is $100,000, and the maximum amount for an entity, a body corporate, a company, partnership, LLC, in relation to a very serious breach is $1 million. In relation to serious breach of a corporate entity, it's $100,000 and $50,000 for the individual. I had mentioned previously the fine principles and criteria. So when the authority are determining whether to impose a discretionary fine, serious or very serious, and the amount, it must obviously consider all relevant factors, the prescribed criteria, and the 4 principles. Now, the 4 principles are taken from the monetary authority law, criteria set out in the regulations. The 4 principles always prevail over the criteria, and I only mention this as the principles guide the decision-making process of the authority. And the 4 principles are in section 42F of the monetary authority law. And in the following order of importance, they are: 1. The need to promote and maintain a sound financial system in the Cayman Islands. The disgorgement principle, the idea that the entity or the individual should not gain or avoid loss from a breach. Disciplinary principle, self-explanatory, and the deterrent principle, again, or deterrence principle, again, self-explanatory. So we've looked at those principles, and those 4 principles are always above the criteria. The criteria are within the regulations, and the principles are within the law. The admin fine regulations list both subjective and objective fine criteria for the authority to consider. And these include, as we can see on the screen, the nature and seriousness of the breach, the degree of the party's inadvertence, intent, or neglect, duration of the breach. Number 4, the measures or precautions that a reasonable person acting prudently would have taken to prevent the breach, whether there was an intent to conceal the breach, party's conduct upon becoming aware of the breach, damage, harm, or loss. These are all things that are within the regulations and things that must be taken into account when calculating the amount and making a decision as to whether or not to impose a discretionary fine. So, fine criteria, prior conduct. Again, a history of compliance of the party in the 5 years preceding the breach in relation to the regulatory laws and AMLRs will be considered by the authority. And again, the CIMA can consider the party's conduct in other jurisdictions. In determining the fine amount, there are additional criteria for the authority to take into consideration, and those are listed on the screen. So aggravating and mitigating circumstances, all of these will be taken into account, and of course the resources and ability to pay. So moving on, let's look at the fine process. So once all of these things have been determined, the authority will come up with a figure and come up with a list of breaches, and they will send out what is known as a breach notice. The breach notice will inform the party of the authority's intention to fine, and it has to state the following information. Of course, the party, the nature of the breaches and the prescribed provisions, a summary of the facts and circumstances as relied upon and as probably uncovered during the investigation process, the proposed fine amount, and the fact that the party will have a minimum of 30 days, depending on whatever's in the notice. There'll be a date in the notice to reply. And in relation to fixed notice, the party may file a rectification notice. We will discuss that in the subsequent slide, but that only applies to fixed fines. So the breach notice will be sent out, and it has to be clear as to what the breaches are and the facts that the authorities seek to rely upon. The party will then have a minimum of 30 days, but the date will be on the breach notice to reply, and that reply will be a reply notice. Now, at this time is the party's opportunity to provide written representations and evidence as to why either A, we should not be fined, B, the fact that there perhaps should be a fine, but the amount should be less. So this is the opportunity for the party to make written representations. And CIMA under statutory duty to reconsider any new circumstances that are brought to the attention upon receipt of the reply notice, and to reconsider the matter if new evidence or any new information or any information is before them. They will reconsider the decision to impose a fine. On the basis that either A, the party does not choose to file a reply notice or does not provide sufficient evidence or reason to not receive a fine, then the authority will then send out what we call a fine notice. However, in relation to fixed fines, as I mentioned earlier, and this is for fixed fines only, upon receipt of the breach notice, the party are able to rectify the breach within 30 days. They should inform the authority of this. The authority will then reconsider whether the specified breach has been rectified to the authority's satisfaction, and if so, will not proceed with the fine. So the rectification notice is only for fixed fines, not discretionary fines. So if the authority is satisfied that the breach has been rectified, the authority will not issue a fine notice for the breach and give the party notice of its decision to do so. However, in relation to both fixed fines and discretionary fines, if the authority is satisfied that a breach occurred and there has not been a rectification in relation to fixed fines, they will issue a fine notice. Fine notice will name the party and also the fact that the authority has imposed a fine for a specified sum and list the breaches. As you can see on the screen, there are other items that have to be included, and most importantly, other than the amount, is when the fine must be paid, and the fact that the parties do have an opportunity to lodge a review for fixed fines or an appeal for discretionary fines. And note that the amount in the fine notice cannot be more than the one or the amount stated in the breach notice. It can be less, but it cannot be more. One of the items that we often get questions on is the question about a discount or discount agreement. We'll call it an early settlement agreement. Now, this is something that is available to parties, and it's available up to any time before the issuance of the fine notice. So if the party knows during the investigation stage that it's going to be fined, perhaps you can do so then, And certainly once it's received a breach notice, the party can then enter into negotiations with regard to an early settlement agreement. The authority will then still conduct an investigation and confirm that the breach occurred and the facts surrounding it. Negotiations are conducted by persons in CIMA and approved by the MD. On to appeals. So following the receipt of your fine notice with the amount and the breaches, all fine notices will need to state that the party has the right to appeal. In relation to fixed fines, party must first apply to CIMA's management committee for an internal review within 30 days of receiving the fine notice. And the procedure for appealing the fixed fine is on the screen before you. But CIMA will perform an internal review and communicate the result. If, for whatever reason, the party still feels that the internal review was not satisfactory, and an option to apply to the Grand Court for judicial review, with leave, of course, of the Grand Court, is available. I'll speak a little more on the idea of judicial review on the next couple of slides. So in relation to appealing a discretionary fine, the process is slightly different. If you remember, discretionary fines are the ones that are slightly larger, or can be slightly larger. A party, again, has 30 days to lodge an application for permission to appeal in the Grand Court at the Cayman Islands. And then the party must receive permission from the Grand Court before lodging the appeal. They may also apply for a stay of the fine pending the appeal, but it's not automatic. Now, for a fixed fine, it's fixed at $5,000, and therefore the party cannot appeal the amount, only that it should not have been imposed. And in each instance, you must obtain the permission from the Grand Court, and the authority may apply for security for costs. Now, one of the things I'd mentioned previously were that the grounds of appeal are those allowed under judicial review. It's not intended for this to be a new hearing. So therefore, the only grounds on which an individual or party may appeal are those of illegality. The authority did something illegal. Procedural irregularity, in that the authority did not follow its procedure. What the authority did was irrational and or disproportionate or lack proportionality. Those are the grounds upon which an appeal can be made. And the powers of the court again are listed or stated within the legislation. And the court have the power to affirm, set aside, or vary the fine. They may also remit it back to the authority for reconsideration. And very importantly, the appeal will not consider new evidence that was not before the authority. This point makes the reply notice very important, because the reply notice is the opportunity for the party to provide its evidence. Moving on to enforcement. The fines are not kept by CIMA. Outstanding fines are debts to the Crown or the Cayman Islands government, and there will be a due date within the fine notice. Due dates and payments may be negotiated with the authority. There's of course interest, but in terms of enforcement, the Crown may apply for the winding up of a company as a creditor, or the debt may be recovered by any other civil proceedings. And that brings us to the end. If you have any questions about this presentation, please send them to contactlegal@cima.ky. We will not respond to questions on individual cases, as this presentation is in no way intended to be a substitute for legal advice or for speaking to the appropriate individuals within the authority. If you have any questions regarding a specific matter, please contact the appropriate head of your supervisory division. Thank you very much.